everyone, welcome to VISHNU IAS Academy YouTube channel. So in the journey of UPSC, current affairs plays a most important role because in the UPSC journey or in the process of UPS in all the three levels, that is a preliminary, mains and a personality test, that is interview, in all the three levels current affairs plays a major role. So that's why the current affairs events are very important. So one of the important recent current affair, so we are discussing about the 48th Chief Justice of India is N.V. Ramana, Justice N.V. Ramana. So this name is suggested by present Chief Justice of India Bobde. So about this particular event, we will discuss complete details about this particular N.V. Ramana as well as what is the appointment procedure of Chief Justice of India as well as judges and removal procedure and tenure and all these things, obviously very important in the exam point of view. If you observe the previous year preliminary questions or mains questions, analysis point of view, mains questions are obviously very important about this particular points, as well as in a prelims level also directly related to this Chief Justice of India, we can expect questions directly maybe related to appointment process and tenure and removal and all these things, definitely very important. All these points very clearly we will focus about CJI as well as N.V. Ramana. All these details will focus. Definitely all these points will help in UPSC preliminary, mains as well as personality test. All these points are very important. Focus very carefully. If you watch this complete video, definitely you will get full clarity about 48th Chief Justice of India or complete procedure, appointment procedure of CJI or judges and removal procedure, everything. So just look into these particular important points in this particular case. Actually, why this CJI or 48th CJI Justice N.V. Ramana is in the news? Obviously, the present recently. So N.V. Ramana is actually senior most judge of the Supreme Court, has been recommended by Bobde, S.A. Bobde for the next CJI of India, Chief Justice of India. So Bobde is recommended his name, so because he is the senior most judge of the Supreme Court. So that's a main important point. That's why this particular point is in the news. Justice Ramana will take over the 48th Chief Justice of India from 24th April. He is taking over this CJI from 24th April till his tenure will end by 26th August 2022. Clear? So another important point related to this tenure of this CJI 48th CJI N.V. Ramana is particularly special compared to previous all the tenures of the every CJIs, that is 47 CJIs. So this particular tenure is very longer period, so more tenure. So this is the longest period tenure in the CJI history, that is up to 47 CJIs. So the 48th CJI having the longest tenure. This is also one of the important point. This is also one of the special in this particular history of the CJI. Now we'll go into the complete details, everything about Justice N.V. Ramana as well as the procedure of CJI, appointment procedure and removal procedure, and everything we will take one by one very clearly. If you observe first, if you talk about Justice N.V. Ramana, what's a brief history of this N.V. Ramana? So what are the achievements, what he done in his career of justice, right? Now if you talk about N.V. Ramana, is from very poor family, that is agricultural family. He born in 1957 August 27th. He belongs to AP, Telugu person. So Andhra Pradesh district of a Krishna district, Andhra Pradesh. And another important achievements in his career, if you talk about, the first important thing is in June 27th 2000, he appointed as a permanent judge of Andhra Pradesh. Similarly, so he functioned as a acting Chief Justice of Andhra Pradesh High Court in this period, March 10, May 20, 2013. Just observe the vast his complete career. So no need to add and all these numbers and numeracy, all these things here. Now particularly September 2, 2013, elevated as a Chief Justice of Delhi High Court. Just observe his graph. The first is the permanent judge of AP High Court. Then he is taken acting Chief Justice of Andhra Pradesh. in particular period, then is elevated as a Chief Justice of Delhi High Court. Similarly, in 2014, elevated as a Judge of the Supreme Court. Then the present important thing in this particular, in his career, what type of things, vast kind of experience is there, this particular Justice Enviramana having different kind of vast experiences are there in the field of this particular law. Now let's see what important points are there. So Justice Ramana specializes in the constitutional, criminal, service and interstate river laws. Particularly, Justice Enviramana specializes in the interstate river as well as criminal services and constitutional service and all these kind of laws. He is very specialized in that particular thing, as well as from all these points we can say that he has a vast kind of experience in this particular field. Similarly, he has participated High Court of AP, Central and AP administrative tribunals. He worked in tribunals also, right? And the civil, labor, services and election matters in the Supreme Court. He participated in civil, labor, services and election matter. Just observe here. So how many vast kind of experience he has. So these are the important points related to the Enviramana, right? These just briefly you have to remember all these points. Next, completely if you focus, generally what is a appointment procedure of Chief Justice of India, or particularly if you talk about judge, what is the appointment process? Now in this case, appointment of the judge in a history of polity, or if you talk about this law or in the High Court and Supreme Court, we have important points are there. That is the first judge case 1928, the second judge case 1993, third judge case 1998. These are the three important timelines, very, very important you have to remember. So definitely for prelims point of view as well as mains point of view, so these benchmarks cases definitely we have to remember. In a polity point of view, definitely whenever you are talking about CJI, judge or whatever, in the appointment process, these, so fourth case is also there, but these three cases are very much important. Now first one by one we have to talk about the first judge case 1928. So what it says, what important points you have to focus here. The consultation does not mean concurrence. Why you are taking this word consultation? Very important. So why we are taking that word consultation means, generally whenever we are appointing according to the constitution, whenever we are appointing a judge, so that CJI consultation process is important generally. So in this consultation process, this consultation process does not mean concurrence. In the first judge case, so the court is declared the consultation does not mean concurrence. That is important. You have to remember this word. This is only implies exchange of views. It's not concurrence, it's just exchange of views. So this is an important point you have to remember from the first judge case, right? These three judge cases, every point you have to remember, prelims point of view as it is you will get, and mains point of view also we can use these points. Then second judge case, what it says, clear. The meaning of the word consultation, it's always revolves around the consultation. See, the previous meaning is consultation does not mean concurrence, it's a exchange of views. Consultation means just exchange of views, but the same meaning we are changing in the, so court is changed the meaning of that particular consultation in the second judge case 1993. In that what it says, the consultation to concurrence, consultation to, it's a concurrence. That means, so advice tendered by the CJI is binding, not the president, on the president. So advice tendered by the Chief Justice of India is binding on the president. This point you have to remember, as well as CJI would tender his advice after consulting of two of his senior most colleagues. In this particular second judge case, what they are saying, the advice tendered by the CJI binding on the president, and the CJI has to give this is tenderness based on after consulting two of his most senior colleagues. That is important. Here, two of his most senior colleagues, you have to consult and you have to tender his opinions to finalize or to appoint a judge. Right? These are the points they given in the second judge. First judge case, consultation means it's an exchange of views. It's not concurrence. But in the second judge case, that meaning is changed to concurrence. That is important. Similarly, in a third judge case, again it is changed. What happens here? The consultation of plurality of judges. Consultation is the plurality of judges. Plurality of judges means what? Just as it is terms you have to remember. Sole opinion of CJI does not constitute the consultation process. Just all single CJI decision is not the consultation process. That is, see, plurality of the judges, the multiple judges are required to select or to appoint the judges here. Now, what is the meaning of that? So, CJI should consult a collegium system. This word is obviously very, very important in this particular process. Collegium system. CJI, that is Chief Justice of India, should consult a collegium of the 4 senior most judges of Supreme Court. So whatever we are taking in all the 3 judge cases, the first judge case we are taking, the consultation is just exchange of views. Second, again we change the meaning of the consultation to the concurrence. Again in the third judge case, what the court is saying, the consultation is not single CJI's decision. It's a plurality of the judges. Plurality of the judges means, so one collegium should be there. What does that mean here? So that CJI should consult collegium of 4 senior most judges. Collegium means what? 4 senior most judges and Chief Justice of India have to decide based on this particular point. So the 4 senior most judges of the Supreme Court. This is a final important benchmark case here, that is third judge case 1998. See, in a polity, if you are talking about any topic, so some kind of benchmark cases are there. Every case is very, very important in the exam point of view. That may be prelims, that may be mains level, definitely very, very important. In this particular point of view, whenever you are talking about judges, CJI, these 3 cases are important. So in the third judge case, whatever we are taking, collegium system, this is based on the collegium system. So we have to appoint a judge. Now what is a fourth judge case? What happens in this? Just if you observe, but first 3 cases are very much important. Now in a fourth judge case in 2015, what changes it happened here? If you observe, in 99th Constitutional Amendment Act in 2014, the National Judicial Appointments Commission Act 2014 replaced. See, this 99th Constitutional Amendment Act 2014 and the National Judicial Appointments Commission Act of 2014 replaced, what it replaced? Collegium system. Whatever in the third judge case we are taken in the previous case, so judge 1, judge 2 case, judge 3 case, in a third judge case, what finally we are taken? Collegium system is important, not sole decision of CJI is important, not important. So collegium system is what? So 4 senior most judges of Supreme Court plus CJI have to take a decision. CJI should consult a collegium system, that is 4 senior most judges. That is replaced. What? It is replaced with what? Collegium system is replaced with a new body. With this Constitutional Amendment Act, 99th Constitutional Amendment Act, they taken one new body, that is NJAC. You have to remember these points also. NJAC, National Judicial Appointments Commission. So with this body, it is replaced collegium system, that is taken from third judge case. Similarly, what happened here? In 2015, again one more decision is taken a court, that is Supreme Court declared 99th Constitutional Amendment Act and NJAC, this body, as unconstitutional and void. See, if you are taking NJAC and the Constitutional Amendment Act we are taken with respect to this, but Supreme Court in 2015, what they declared, these two things are unconstitutional. Clear? So that's why, so these two will not consider. Again judge recruitment process again depends on, again collegium system became operative. So finally, Judge 1, first judge case, second judge case, third judge case is important, because the fourth judge case again it is in unconstitutional void. That's why third judge case collegium system is obviously very important. These four situations, at least particularly first case to third case, all the judge cases are very most important. You have to remember all these points. Clear? Very simple points. Now, if you talk about appointment of particularly CJI, just now we seen judge appointment procedure. Here, how we will take the CJI, Chief Justice of India. Chief Justice of India and judges of the Supreme Court are appointed both. Just that's why I explained about judge appointment procedure. So, Chief Justice of India, judges of the Supreme Court are appointed by the President. Obviously, this is important. So, by the President. Any judge is appointed by the President, that is CJI, particularly Supreme Court judges. And that is Article 124 so of the Constitution. According to Constitution, Article 124, the President appoints Chief Justice of India and the judges of the Supreme Court. This point is important. Similarly, as for the CJI is concerned, particularly CJI point of view, so outgoing CJI recommended his successor. His successor he will recommend. Observe this time, Bob Day recommended, so Justice N.V. Ramana name, because the Bob Day is a present Chief Justice of India. So according to this, CJI is concerned, the outgoing CJI recommends his successor. Definitely the Bob Day recommended Justice N.V. Ramana name. So these all the points are important. So after suggesting or recommending this name, so then what happens? The Union Law Minister forwards the recommendation to the Prime Minister. After the recommendation of the CJI, the outgoing CJI, it is forwarded to the, so Union Law Minister forwarded to the Prime Minister, who is in turn advises the President. Who advises here? The Prime Minister advises the President. Finally, the President take a decision and President definitely appoints CJI based on this particular point. And see, Supreme Court in the second judge case, 1993, we already taken about that. But what regarding we are taken CJI, important point, ruled that the senior most judge of the Supreme Court should alone be appointed to the office of the CJI. We are appointing CJI, that should be the person should be the senior most judge of the Supreme Court. That person should be the senior most judge of the Supreme Court. Then only we can take as a CJI. But sometimes in the history of CJI recruitment or appointment, CJI appointment, two times they are not considered based on this. So, but again, finally, the senior most judge only we are taking as a CJI. And the Supreme Court Collegium, he is headed by the CJI. We already taken, according to the third judge case, collegium system is important. In the collegium system, the four senior most judges of the Supreme Court along with CJI. So CJI heads that particular collegium system. So four senior most judges, we already taken this point. The collegium system is the system of the appointment and the transfer of a judges that has evolved through judgments of the Supreme Court judges cases. We already talked about these judges cases, everything, and not by an act of the Parliament or by the provisions of the Constitution. This judgment appointment of the judges here and the transfer of the judges not based on the law of Parliament or the Constitution. It is based on only collegium system, not on act of the Parliament or not on the constitutional based. It's a completely depends on collegium system. These points definitely you have to focus. Now let's see some other important points. Generally basic qualifications of a judge, right? So these are the general basic points. This is obviously very simple, but remaining points you have to remember. You should have been a judge of the High Court. You should have been a judge of the High Court for 5 years. Should have the 5 years experience as a judge of a Supreme Court as well as the next High Court, and he should have been a advocate of High Court, advocate on a High Court for the 10 years. So 10 years as an advocate in a High Court and 5 years judge of the High Court. These two cases he is eligible for, so judges, and he should be a, this is actually we are talking about Chief Justice of India. So qualification for Chief Justice of India, and he should be a distinguished jurist in the opinion of the President. In the opinion of the President, that person should be a jurist. That is also important. So these are the important points regarding qualification. If you talk about the tenure generally, according to the Constitution is not mentioned any fixed the tenure of the judge of the Supreme Court. The Constitution is not fixed any particular tenure. But on what basis we will decide, we will remove that particular person, or on what basis we will take the tenure here. Now if you observe, he holds the office until the age of 65 years. Until the age of 65 years, right? Then he can resign. He can resign office by writing a letter to the President, resignation to the President. So first thing is, he can, once he appointed as a judge or Chief Justice of India, he should be up to 65 years, until the 65 years. And next important, he can resign by writing a letter to the President. These type of points very, very important. And next, he can be removed from his office by the President only. By the President only, on the recommendation of the Parliament. On the recommendation of the Parliament. It's not only depends on President, but this compulsory made by the President only, but on the recommendation of the Parliament. On some certain grounds, that grounds also we will take. These are general tenure details. As well as if you talk about removal of the judge or CJI, or generally what basis we will take. According to the Article 124 in the Constitution, what it says, lays down the procedure of the removal of the judges of the Supreme Court, which applicable to the CJI as well. Clear? So removal procedure of the Supreme Court judge is applicable for CJI as well. That is important. Now, what procedure is that then? He can be removed by an order of the President passed of an address by the each house. It should be addressed in the each house of the Parliament, supported by, this word is important, majority of the total membership of that house. When we have to consider, definitely, see, he can be removed by the order of the President only, but it should be addressed in both the houses of the Parliament. Both the houses of the Parliament, that is supported by majority of the total membership. Majority of the total membership of that house, with the majority not less than 2/3. Majority not less than 2/3 of the members of that house present. This condition is important. So Parliament is supported by the majority of the total membership, and that voting should be not less than 2/3 of the members of that particular house present. The voting has been presented to the President in the same session for such removal on the grounds of provided misbehavior and incapacity. So Chief Justice of India or Judge of the Supreme Court removed based on this particular grounds, misbehavior or incapacity. On these grounds also, all these procedures we have to follow. These are the important point related to the recruitment appointment process of the CJI judge, as well as important landmark cases we've seen about RAMANA we've seen, and as well as we taken tenure details, as well as we taken complete removal procedure of judge and CJI. And another recent update regarding this, these kind of recent developments also we have to focus. The previous 1-2 years recent development, what important developments are there, everything we have to focus. We have to relate to the current events also. In a UPSC prelims or mains, definitely relations obviously very important. You have to relate this current events to the recent current events of the past. Now let's see what is a recent development in this. In 2019, Supreme Court ruled that Office of the Chief Justice of India comes under the preview of the Right to Information Act. So even Chief Justice of India office also comes under RTI Act 2005. This is the recent information, the recent developments. These kind of recent related questions also we can expect in prelims directly based on these points. So these are the important points regarding this particular news and events. Regularly in VISHNU IAS Academy YouTube channel, we will provide these kind of interesting informative videos regarding current affairs event and everything related to UPSC preparation. But definitely if you follow regularly, you will get more and more content. Definitely if you like, definitely just like the video as well as share to your friends also. If you are watching the first time VISHNU IAS Academy YouTube channel, so please subscribe and regularly follow this particular channel. Definitely you will get more and more content very easy and simple way. Thank you friends.